My lord, may I phrase it, my lord, in item number, my lord, 6, my lord. We have, my lord, this morning only, we have filed, my lord, one IA for impleadment, my lord. That may be called for, my lord. In item number 6, my lord.
Item 6.
Yes, my lord.
Okay.
Not yet been served the copy.
The copy will be served.
So I need to go through all.
Yes, yes.
Okay.
It is just for impleadment only.
Okay, that may be called.
Yes, much.
May I,
Case I also have filed one day.
Okay.
may I, Your Lordship? Lordship, I beg to mention item number 16 and 17. This matter to be listed after 2 weeks, Your Lordship.
After
Hearing matter.
Okay. Who is for the petitioner? Is
Yes, I
he-
have informed Your Lordship.
Okay. Ms. Pango, Ghana Government Advocate. Praise for listing this matter after, with the consent of the Atlantic Council for the petitioner. Praise for listing this matter after 2 weeks. The prayer is allowed. List it accordingly after 2 weeks.
Obliged, Your Lordship. And also item number 18, Your Lordship.
Hmm.
This matter to be listed on this 25, Your Lordship.
Here also you have obtained.
Yeah, petitioner.
Yes, I'm for the
Okay.
petitioner, sir.
Okay. Praise for listing this matter. When you said
25th,
25.
22, to which Mr.
J. Ninu.
Atlantic Council appearing on behalf of the appellant has no objection. Prayer allowed. List is accordingly on
25th.
Lordship,
Okay.
25th is Monday.
25th is Monday. No, not on Monday, Tuesday and Thursday. Then it will be 26.
Okay, 26, Your Lordship.
Okay, Your Lordship.
Okay.
Obliged, Your Lordship.
Much obliged.
Lordship, I recommend item number 2 and 3. With consent from the other parties, I pray that the matter will be listed after 3 weeks, Your Lordship.
Okay. After 3 weeks.
Yes, Your Lordship.
This was already admitted also. Okay. Mr. You are for the petition
Appellant, yes.
appellant.
Yes. I'm K. Taja.
The appellant was appearing 1 and 2.
Yes, yes. All the parties appellant. There are many parties.
Item 1 and 2.
Yes, no, 2 and 3, Your Lordship. 2 and 3.
2 and 3.
Yes, Your Lordship. It is same matter, similar matter.
Okay. Mr. K. Taja. You have informed the,
Yes, yes.
okay. Atlantic Council for the appellant with the consent of the Atlantic Council for the respondent. Praise for
3 weeks, Your Lordship.
adjournment of the matter for 3 weeks. The prayer is allowed. List the according after 3 weeks. Okay.
Yes.
My lord, I beg to mention item number 7 for adjournment.
7. Criminal appeal.
Yes, my lord, I'm on behalf of appellant.
Just a minute. You are for the appellant.
Yes, my lord.
Miss
Here are you.
Atlantic Council for the appellant. When do you want to say? After?
For 3 weeks.
Okay.
After 3
Praise
weeks.
for adjournment of the matter for 2 weeks. 2 weeks, Mr. Atlantic additional PP has no objection. Prayer allowed. List this matter after 3 weeks. Okay.
Obliged, ma'am.
Obliged.
Your Lordship, I beg to mention item number 8 on behalf of C. Modi.
See Modi.
Yes, Your Honor.
Who is for the respondent? Reply.
Government
You have
advocate.
not yet filed. Okay.
Yes, Your Lordship. We are yet to file an
Have you
affidavit in
from the other
opposition.
side?
Yes. Sure.
Okay. Miss
BD Esther
Praise for Father. How much time you said?
for 3 weeks.
Praise for Father 2 weeks to file affidavit in reply. To which the Atlantic Council appearing on behalf of the respondent has no objection. Prayer allowed. List this matter after 2 weeks to enable the petitioner to file affidavit in reply. Okay.
Much obliged. Your Lordship, I beg to mention item number 13. I'm here on behalf of the counsel for the respondent, B. Picha. Lordship, we have filed a Wakalat Nama, but our names are not reflected on the cost list. Kindly, the registry may be directed
It's for order. Wait for
13.
Okay. Wait for some time. We'll pass order. Okay.
Sure, Lord.
And pass the order.
Item number 1,
The matter, it appears, has already been admitted.
Oh, yeah.
So you are praying, yeah, by this, you are praying for. What is this?
Hello there. I am appealant in writ appeal. In view of appointment order dated 5/5/26, I beg not to press this writ appeal.
Order has been already passed,
Yeah, appointment order.
already
I got-
passed. So
yes.
you don't have any grievances now.
No.
So you want to
Okay.
withdraw this.
Yes.
Okay.
So we can keep this on record.
Hmm.
We can withdraw.
Mr. Raghuvinder Rai, petitioner in person. Submitted. This is in person of the order.
Yes.
Okay, in person to the order of this court.
No, not in person to my lord. He got appointment on his on merit, my lord. On merit. He on merit, my lord. They are department in other post, my lord.
Okay.
LDC, my lord. So he don't want to press this.
Oh, in other department.
No, my lord.
No,
Not
same
other post, my lord.
Other-
LDC, my lord. Now he has
Okay,
been.
okay. Submitted.
Or you can simply say that there are any grievances.
Okay. Submitted. He doesn't have, submitted. He has no more grievance. He doesn't have any further grievance in the case. Therefore, he wants to withdraw this writ appeal. The prayer is allowed. This writ appeal is dismissed as withdrawn. Staff. The in view of the order passed today insurance, so I also disposed. Okay.
Obliged.
item number 4,
May I please, Lordship? Lordship, on 5/11/2025, the government council was directed to obtain a status report of the disputed land. Status in Baba.
Status, I have already lordship. Lordship, latest status is that lordship,
You had
land
to obtain
allotment-
instruction.
Land allotment is already cancelled. There was a contempt petition before this, before the single bench lordship. On account of the cancellation of the allotment, that contempt has been closed already. So even this appeal, WA becomes process
Lordship,
accordingly.
may I please, Lordship? Lordship, my case is, Lordship, the government has accorded an approval for allotment of 4,000 square meters of land in my favor, Lordship. But before cancellation, same land was, Lordship, allotted to two individuals, private respondent number 6 and 7, Your Honor. Then I approached before the authority regarding subsequent allotment of that
So
land.
those were cancelled now.
Lordship, may I coming on that point, Lordship? Now, Lordship, without ground, it was cancelled. But when I filed a writ petition before the learned single bench, now government has taken ground that, Lordship, that land falls within the forest land, Lordship. Since from the writ proceeding, Lordship, they have submitted a statement before the learned single bench saying that the process for cancellation of land allotment in respect of private respondents 6 and 7 was going on, Lordship. Now, Lordship, it's 2016, Lordship. Now they are saying that their allotment has been cancelled. So, Lordship, to that effect, Lordship, at least status of the land, Lordship. Now, if they have initiated for cancellation since 2022. The land has to be under the possession and control of the respondent authorities, Lordship. Now, therefore, Lordship, subsequently on 5/11/25, this Honorable Court has directed the government to produce the status of the present status of the land, Lordship. The cancellation they are showing in the paper only, Lordship. Because their statement, same statement that have been made since the writ proceeding, Lordship, that the proposal for cancellation is going on. Until today, only they have shown the cancellation on 2026. So, Lordship, in that regard, may I humbly pray that the status of the land may be called for. Current status.
That is the status probably.
Status is
Status, this is regarding the cancellation, Lordship. But if they cancelled, if my allotment was cancelled, saying that the land falls within that notified area, forest land or within the June land.
Probably that is the same reason they have cancelled it, or is a different reason?
No, Lordship.
Same reason, forest land.
Lordship.
Then the status is there, it's a forest land.
But-
It's been already recorded in the contempt case, Lordship.
But out of record, Lordship, make a submitted that the land is physically still under the possession of the respondent number 6 and 7. Now, if they have intent to cancel their allotment, why they have not taken any action
Bring it on,
regarding that?
then, you bring it on record by filing affidavit then. The cancellation, and also say the
Current status of the land, yes. They have to taken physical
have to say
possession
that
of the
it's-
government land, Lordship.
It's the status report. Status report is of November 2025.
But it says the respective plots are currently under possession of previous allottees.
Yes, Lordship.
In the status in November, Lordship.
So you should bring in, November 25, why you have got the old communication? You should have got the present status. Because today we are in May, in the month of May. So probably the government has taken some stand for evicting them or whatever, because allotment is no further renewed. Correct? So some status should have come.
Yes.
Contempt order is of this April 2026.
Yes, contempt, but you're producing this. Contempt is only regarding whether it was cancelled or not.
Yes,
So they have cancelled it, that's why the contempt was closed.
yes.
They have taken an active this thing for active action for cancellation. So that's why that was closed. Now only thing is that whether you are allowing the previous why you are allowing the previous allottees to occupy the land. That is the question he is raising.
Yes, Lordship.
So that status you should bring in, because this is a November communication.
Lordship, to that if the Lordship order me to
Bring on record the latest status, because this is, as per this, the respective plots are currently under the possession of the previous addressee, still under.
Yes.
And that is what he is problem because of this.
So as he is saying that this is only on paper, nothing has happened
Yes, Lord.
on the ground. So he bring in what is happening on the ground.
Okay. Mr. K. Lolling and counsel for the petitioner. Stuff. Ms. G. The Learned Additional Senior Government Advocate. Some mystery. She has received the status report and then press for allowing her some time to file and bring it on record by filing additional affidavit. Okay.
affidavit form, Lordship.
In the affidavit form. Okay. In the affidavit form. How much time?
Lordship,
Status?
3 weeks time.
3 weeks.
If
Okay.
not 2 weeks,
Yeah.
time may be allowed.
Get the latest status. This is of November. Okay. 3 weeks time. Prayer allowed. List is after 3 weeks. list this matter after 3 weeks. Okay,
Lordship, status of the land.
yes.
Deeply obliged.
Item number 5.
Lordship. In this case, Lordship, I need some time to file my rejoinder affidavit, Lordship.
Okay,
Government has filed,
not yet filed, yes.
not yet filed, Lordship. I need some time.
Okay.
Government
No,
has filed, means I have to
He
file.
has not yet filed.
I have not filed, that only I had submitted.
Miss D goes. Grant time. Grant time. How much time?
Lordship, we need to adjust 4 weeks' time, Lordship.
4 weeks. Probably you, this is regarding.
You're not going to fix that?
Yes.
I'll pray.
Miss D goes, land counsel for the petitioner. Prays for further 4 weeks' time to file affidavit in reply, to which Miss Land senior government, Land additional senior government advocate is no objection. Prayer allowed. List this matter after 4 weeks.
Lordship, I'll humbly pray for
Okay.
a fixed date, Lord.
When? June 10?
June 10, it's not, it's
Okay.
a Wednesday, Lordship.
Sorry,
Maybe on 18,
18 June.
18 June, Lordship.
Okay.
Item number 6.
Lordship, respondent number 2 has, in this case, Lordship, respondent number 2 has filed their affidavit, and today I have just filed my rejoinder. It's yet to be there. on the
My lord,
record.
sorry for the interruption, my lord. My lord, today actually is fixed for my lord, as last time also I raised the preliminary objection, my lord. Now the preliminary objection has today, my lord, the mental limit of the present PL, my lord.
Let
That has to
my
be heard.
affidavit, rejoinder affidavit, he
that's
has
all right.
filed his affidavit.
That is all
So
right.
I have filed my rejoinder. Let it come up on the record. And in the affidavit, there is no sense that the maintainability of the PIL.
No,
And
it's
we
a
have not,
legal point. No,
we
it's
have
a
not.
legal point, my lord. Legal point has
There are
to be
judgments of
interpreted, my lord.
Honorable Apex Court and even of the.
Right from the
Honorable
beginning,
High
my lord, I've
No,
been
no, no,
urging my lord
One
to
at
file
a
a
time, sir.
mental limit of petition, my lord.
No,
It's a
that's
legal
fine.
point, my lord.
Since he has filed and replied, let it be on record. I mean,
Yes,
we'll give a
Lordship.
short date. I mean, we are not going to give a
Yes, Lordship.
long date, or let it be on record.
My lord, I am not saying that, my lord. Why this case was listed today? That just want to apprise this call. It is because of my last prayer, my lord.
Correct, we understand that, but only
that's
thing is
all, my
that
lord.
since that has already been filed, copy has been served to you. You also go through that and let the court also go through this, what stance he has taken.
Okay.
My lord, that will be obviously on merit, my lord. Other pleadings, my lord, that will be on merit, my
Goes,
lord.
land counsel for the petitioners.
And in
Was
this matter,
submitted.
I'm sorry, madam. In this matter, madam, we have filed, madam, the IA for impleadment, madam. Madam, in the petition itself, madam, if lordship perused the madam, the entire petition.
You are representing whom?
Madam,
Who filed for impleadment?
madam, just for a moment, madam, the statement has been made against the madam, the all Arunachal Pradesh Students Union. Madam, the all insisting on the part of madam, insisting by the madam, the APSU, the PRC, madam, illegally issued in favor of them, madam, has been cancelled by the state government, madam. That is the whole environment, madam. Madam, admittedly, we are, madam, the spearheading the issues. Therefore, madam, the granting of the PRC or any other documents to these foreigners and the refugees, madam, is not at all, madam, permissible in the law, madam. Even, madam, the petitioner has specifically mentioned in some paragraph wherein, madam, specifically mentions that the only insisting on the part of this student organization, madam, the cancellation has been done by the state government, madam. May I take your lordships to the page, para 13, page number 16, madam.
Before one submission, before my learned senior friend argues, Lordship, he is now appearing for Arunachal Pradesh Student Union. Already he had appeared on 7/1/2026. He has appeared on behalf of the Union of India. So whether it is a conflict of interest,
No,
Lordship.
madam, I'm not appearing on behalf of the Union of India.
No, he had appeared in this particular matter, Lordship, on 7/1, Lordship, 2026, on behalf of the Union. So Union stand before the Apex Court and even before the Delhi High
Others
Court.
also, madam, we are
So,
the
Lordship-
same respondent, madam. Otherwise,
cannot-
also there is no chances of the clash of.
See, union and students union will be totally different.
Exactly, Lordship.
But my lord, on the many occasions, my lord, if my lord, if I am remember correctly, my lord, my name may be
See,
wrong.
all matters are different.
I am not appearing on behalf of my lord in entire my lord.
But you have already appeared. that's what-
Yeah, on 7-1, Lordship, 7-1. And even the 7-1 he had appeared and his name
Who is
reflects.
appearing for the Union of India?
My
So
brother.
later on, he has changed. So it's a conflict of interest, Lordship. Just I want to point out before this honorable. court,
Otherwise, also
Lordship.
my lord, that can be my lord considered. There is no my lord such clash, my lord. We are not against each other, my lord. We are in the same footing, my lord. Even if Union of India is also on the same
Yeah.
footing, my lord.
Even the union
There is
stands
no
for
matter
the
the-
Delhi
there-
Court, High Court, Lordship.
There is
No.
no my lord the prejudice, no my lord
Mr.
the clash
Kato,
of
you
interest.
have
Otherwise, the
already appeared on behalf of the union as DSTI only on 7-1.
my lord, I'm sorry to say, my lord, that part I have not gone through, my lord.
No. So you appeared.
Yes, my lord. Still then, my lord. But my lord, my submission would be, my lord, there will be no clash of interest as because we are in the same respondents and my lord, the contentions of the Union of India and the state government as well, my
It
lord.
becomes difficult, Mr. Kato.
My lord,
See, you are representing the union,
my lord.
and at the same time, you are representing a private organization.
Private organization, my lord, who is the spearing heading of these issues, my lord, particular.
Correct. So
My lord,
there are
just to my lord, the price, even in
there are allegations against your organization. That's what you're saying. There are
Malad, so-
allegations against your organization. That is what the submission is, right?
yes, ma'am.
So the stand of union government should be neutral in this matter.
Exactly.
And your
Exactly.
thing is that like, you have some
Malad,
role to play there.
Another position is, Malad, relating to this students organization as well as the Malad, the student organizations belongs to Sakma and Azan community, Malad. Matter is still pending before the Honorable Supreme Court, Malad, for consideration, Malad. That particular paragraph is
No,
also.
those things that probably considered.
So therefore, at this
those things
stage,
will-
Malad,
those things-
Let anyone represent student union because
Yes,
you
Lordship.
already appeared as a DSTI only.
Malad, in that can,
Representing
in that
you.
case, Malad, I'll.
How do we erase this? How do we delete this?
Malad,
How do we delete this order, which we have already appeared?
Malad, I'll file the
Probably
IA.
made some
Malad,
argument.
I'll file IA for Malad, the consideration of that Malad part, Malad.
That we can see if you
Malad.
want to file.
Malad, that's because
Because we can see, but whether grant or not is, of course.
Malad, there's
But
my submission would be Malad. Otherwise,
Why
also
why
the
can't
prejudice
the
will
student
cause Malad.
organization be represented by some other advocate?
Malad, in which case, Malad?
The student organization.
Malad, the student
Because
organization.
yeah,
Malad,
it will be difficult for you because
Yes, ma'am.
at the one you are ultimately ultimately you are DSCI only
Yes.
True, Malad.
and then already appeared also.
Malad, I'm sorry, Malad. I'm not aware of the part, Malad. Maybe
You
Malad.
have appeared. Whom
Malad,
you're asking?
Malad, sometimes it happens, Malad. It is fair to make submission, Malad. Sometimes it happens, Malad, when
In your absence, you mean to say that in your absence this has been recorded that hard Mr. Kato also.
Malad,
No.
Malad, then in
No.
that case, Malad,
No.
may I pray that
We-
Malad,
we-
I may be
we-
allowed to file IA for
No, we
Malad
will not
striking of my name.
will not create any
Cannot be
confusion
struck.
that
Okay,
way.
cannot be
Malad.
struck. No, if you say that if you don't want to appear at all for DSGI, that's a different thing.
Malad.
But once you have appeared there,
What happened in this case, Malad, particularly, Malad, it is fair to make submission before your lordship that, Malad, we are continuously appearing on behalf of this APSU or student
no,
organization.
for different matters, not in this matter.
Malad.
So
Exactly.
So,
different
Malad-
matters you can
Therefore,
appear
Malad-
for up to in any matters. But thing is that since you have appeared in this matter for disease, I mean as DSGI,
Malad.
then how can you appear?
Malad, in that case, Malad, yes, Malad, I'll take Malad, a call on which side, Malad.
You
I-
take instructions because
Malad.
you won't be able to appear for both the parties.
Yes,
It will be
Malad.
difficult.
No, Malad, I am not appearing on the board at this stage, Malad.
Since you have already appeared, so I mean, you have already accepted brief for one party.
Exactly.
Then that party and the other party, you are taking the brief. Whether it will be, it's fair on your part.
True, Malad.
There is a conflict of
Malad,
interest.
I'll take this issue.
So you have filed affidavit in reply. Today.
Yes, Lordship. To
Okay.
respondent number 2, today I filed that.
Okay. Sir, copy too.
Yes, Mr. Nabam, you have anything?
Copy,
all-
have
all-
not
all-
yet received.
Okay.
Anyway, my lord.
I think from to your junior they
Clear,
have.
my lords, this next available division bench, my lord. The mental limit of the present
Okay,
year will be
that-
hard, my lord. No more default.
That has been kept open. Okay.
Then in that case, Malad, may I pray that Malad, I may be kept as it is, Malad, my colleague will appear. And Malad, regarding the Malad appearance on behalf of the Union of India, Malad, I'll take a call from the ministry, Malad.
Because you are the standing counsel. the Deputy Solicitor General of India means
True.
that you'll have
True,
to
madam.
appear for them.
Madam, otherwise, madam, my fair submission is there would be
Next,
no
tell me
any
one
place
thing.
of interest, madam.
Tell me one thing. If there is a matter,
Madam.
and in the matter, can you abstain from appearing for the union and appear for a private party when you are standing counsel? From the beginning, if you say that you are not appearing in the matter because you have some interest in the matter, that's a different thing.
Madam.
But once you appear, you are a standing counsel, correct? You are the standing counsel. So
True,
you cannot say that I will
Madam,
not appear for
the
this.
possibility is, madam, in other department also, madam, I'm a standing counsel, madam. In that
departments
situation,
are
madam, the
different.
option is to be,
You
madam.
are Deputy Solicitor General
True,
of
madam.
India. So standing counsel and Deputy Solicitor General of India makes clear there are
True, madam.
differences.
I fail it, madam.
And you have been appointed to appear, represent the Union of India.
True,
And when the Union of India is a party,
Yes,
you
madam.
are supposed to appear for them.
Yes, madam.
And if you appear for a private party, you say that I don't appear for Union of
Yes,
India, then
But-
you'll have to consider that.
Yes, madam. The endorsement can be also made to the other CGC, madam, since other CGC is also available. True, madam.
That could have been earlier, but now you have already appeared.
Fairly, madam, I have not gone through that, madam.
Yeah, that's fine. That's fine. No, we are not disbelieving you. That's fine. It may happen sometimes that
True, madam.
you appear, you forgot. It may happen.
But one thing you should also remember, and let us not try to create such kind of a situation. Even the junior also will understand that, okay, this can also be done, please. Yeah. Okay.
Madam.
Mr. D goes, Land Counsel for the petitioner who submits that she has filed her affidavit in reply today itself. Okay, Mr. R.H. Nabam, Land Additional Advocate General, is present and submits that he has not yet received a copy of the affidavit in reply, so filed by the petitioner. Mr. So here for DSA,
Malad, I'm sorry, Malad. I'm informed by my brothers, Malad. It was appear by my junior, Malad.
On
On behalf of me, Malad.
No. On that day, he appeared because I was there. I was arguing. He appeared, Lordship. And even it can be, if I'm.
live streaming also.
Yeah, exactly. I wanted to say that. So we can check from the videos.
Okay. So today, whose name should we record?
Malad. Till today, Malad, may I pray that Malad, my brother's name may be reflected, Malad, for Union of India. Malad. Since he's on the previous occasion also, Malad, he's appearing, keep on appearing, Malad. This is maybe fourth or fifth times, Malad, hearing.
And Lordship, union's reply is very important. Stand is very important in this case. Yes, Lordship.
No role in this here. Lordship, petitioner are challenging the cancellation order, Lordship, passed by the state government.
We have so the union stand also is, this is the reason we have made them the party, because before the Honorable Apex Court, when the National Human Rights Commission has approached, and then categorical statements were made against APSU in that particular case, Lordship.
If you're referring to that human rights case, my lord, we have already done the exercise. All the applicants which are found to be valid, we have already recommended to Ministry of Home for citizenship.
And they,
don't link up with that.
Hey, Lordship, we are bringing section 3 of the citizenship. They are by birth Indian, Lordship.
No. See the Supreme Court orders, Mala. See the Supreme Court orders.
Mr. Lawyer, Mr. Lawyer,
Don't refer to that human rights.
you are a
So you take a conscious decision.
CGC.
No,
Recording number 1.
You are appearing for
Recording number 1.
respondent number 1 for the first time only.
No.
Earlier also appeared.
Earlier present.
Here on. Okay. Also made similar submission. Staff. Okay. Mr. R.S. Navunlaned, additional AG, reiterate the issue of maintainability of the PIL.
My lord, so next
Okay.
available division bench, Mala, that should be hard.
As requested, when do you want this matter to be listed?
4th of June, Lordship.
Okay. List. As
4th of
requested.
June, my lord, no, my lord.
List-
My lord, as I've asked, since beginning, my lord, the preliminary objection raised by the state should be hard passed, my lord.
Yes, sir.
Right from the beginning, my lord. Why not next week, my lord?
Next week,
It's
I'm not available because I have outstation other cases.
That's understood, my lord. Time and again, my lord, we accommodate the learned councils, my lord. So
on
other side also issue reciprocate the same thing, my lord.
4th of June, Lordship.
Okay, yeah, fourth-
No interim, nothing is there, Lordship. So on 4th of June, I'm.
June
complete
4th.
day For 4th of June.
June 4th,
fourth of
okay,
June.
It's Thursday.
June. Huh?
It's a division bench day.
Please, on 4th June, huh? On the request of the land council for the.
Then you lordship may
Please
kindly
matter on
specify in
4th
the
June.
orders, my lord.
The
On
issue,
4th June, my lord, the mentality will be hard.
okay, the issue of maintainability. On which date the issue
No
of
issue. Yes.
maintainability shall be
Yes, sir.
considered. Okay.
Mr. Kato, I mean, there was time taken on behalf of you also earlier also. On 31/2026, Mr. M. Taylor, learned counsel appearing on behalf of Mr. M. Kato. So how can we appear?
Don't spoil the image. Okay.
Don't do it.
Deeply obliged.
Mr. Gato is my lord in wonderful, my lord. He is proud, my lord.
Malad, my appearance would be Malad, very beneficial for even deciding the issues, Malad.
No, that's a different thing, whether it's
Well-
beneficial or not, but you'll have to take care of all these things.
Well,
Yes.
deeply.
Item number 9.
May it please lordship. Lordship. I'm from your leader. May it please lordship. Lordship, I'm the legal aid counsel. Yes.
You were to file
Yes.
application for cancellation of delay.
Yeah,
Fine.
yesterday I've received this application from Teju Jail. Today I will filing.
Okay.
This is a POXO matter. So for victim.
You implead the victim.
Yes, I
Okay.
will take steps upon the victim also. There are two victim and one informant.
Legal aid counsel for the appellant submits that he has received an instruction
Yesterday
only and will be filing the application, interlocutory application for condemnation, delay condemnation petition. For which he require how much time?
1 week.
1 week. And prays accordingly. The prayer is allowed. Please this matter after a week.
After 2 weeks.
After 2 weeks.
Yeah.
Okay, after 2 weeks. Mr. Tado will appear on behalf. Tado Lanet additional PP is also present for the state respondent.
These are already received, so paperwork may receive me
Already
direct.
received.
Yes.
Okay. Okay. The trial, since the trial court record has been received, the registry is directed to prepare a paper book. Okay.
Obliged.
Obliged.
Item number 10.
Malad, in this case, Malad, service of notice upon the sole respondent has not yet returned, Malad. It's awaited, Malad. May I pray, Malad, this let it be released after 4 weeks, Malad. In the meantime, I'll just try to trace out, Malad.
Okay. The note, the office note dated 6/5/2025 reflect that the notice upon the respondent number 1 is still awaited. In view of the above, Mr. Tagum Land Counsel for the appellant. Pray for listing this matter after 4 weeks.
Yes, Malad.
Okay. There is only one respondent.
Yes, Malad. Only
Okay.
one, Malad.
Prayer is allowed. List this matter after 4 weeks.
Deeply
Okay.
applied.
Item number 11.
May I plead your lordship? My in this order, my lord, last order, my lord, dated 29/1/2026. As per that order, we were asked to file affidavit of postal tracking consignment. So we have filed the affidavit, my lord.
Okay.
We have filed affidavit. Your lordship may see the affidavit which we have filed after tracking from the postal department.
Okay.
So may I just read paragraph para 3.
Para 3 of?
My affidavit report of postal consignment. It should be there, my lord.
Postal consignment or dusty service? Postal.
Only we were asked to check the postal
This is with regards to respondent number.
respondent number, regards to respondent number 4, 6, 7, and 8.
Who is to file wakalatnama? Earlier appeared and pressed for some time to file wakalatnama.
Respondent number 5 has.
Yes, respondent 5 has filed the wakalatnama.
Have you filed? You are for respondent number 5.
Yes, Lordship.
Have you filed wakalatnama?
Lordship, the respondent had instructed us to file the wakalatnama. However, till the respondent has not appeared in person to execute and submit the wakalatnama.
Okay, not yet filed. Okay.
So at this stage, notice may be issued.
You're on behalf of which respondent?
Respondent number 5.
Okay.
5 only, my lord. So, in regards to respondent numbers 4, 5, 6, 4, 6, 7, 8. As per our postal tracking report affidavit which I filed in the paragraph 2, 3, we have stated that whatever it shows in the postal department records, it shows that just may I read that paragraph 3 of my consignment report said that as on 11/3/2023, the status of the postal tracking consignment report towards respondent number 4, displaying a window delivery. It's as per the window, it's already is a delivery since 19/1/2020 as the official website of Indian Postal. That is against the respondent number 4. And then paragraph 5 of that report, it also against the respondent number 7. It also says that, may I read that one?
Well, 6 is fine. 7, I mean, no updates.
7, it says that transmission to Anelli headquarters. It is where they are staying. This is the headquarters, my lord.
Then 8 also window delivery.
8 also windows as a delivery, yes, my lord.
Window delivery means somebody has come there and received it.
Receipt, yes, my lord. 5 also, my lord, it also, my lord, it also shows that display item transmitted to Anelli headquarters. This is the address of that particular respondent, my lord. So it also shows that notice has been served to the private respondents.
So according to you, all have received.
As per postal tracking, yes, my lord.
Where is their address?
Yes, my lord. Address is, my lord. It's page 5, my lord. Let me see page 5. Page 5, respondent number 4 is in Italian. And 5 also Italian. 6 also Italian. 7 also Italian. The PS is Anini, but then postal service is Italian. Post office is Italian.
This was step was taken by way of
speed post.
Yes, speed post, my lord.
I think you have to take a substitute steps upon them by a substitute way. We need to ensure that
Otherwise, respondent number 4 appears for all in the writ petition in the before the single bench. 5.
5.
Yes.
5 is also not appearing to sign wakalatnama.
5 appear, my lord.
No,
So in that case,
he's saying wakalatnama hasn't been filed as yet.
the respondent number 5 hasn't come.
Or otherwise, your lordship may first that we can serve extra copy to the respondent 5 because
Let the respondent number 5 appear first. because he is also not coming to sign wakalatnama. The respondent number 5, see, that is awaited. So how much time you are seeking for to file wakalatnama? When he can come? Respondent number 5, come to you.
Assist her. Okay.
Who is your senior?
I'm on behalf of K. Saxena.
Saxena, okay. So tell him, okay, we are giving 3 weeks time. Within this 3 week time, you call the respondent number 5 to sign wakalatnama. And when he appear, we'll ensure that is he also appearing for other respondents.
Other responses.
Okay.
All right.
Okay. Miss, your good name?
BA.
Learned Counsel for the Learned Counsel submits that although they have informed the respondent number 5 to come for signing the wakalatnama, he hasn't come yet. Therefore, prays for further 3 weeks time to file their wakalatnama. The prayer is allowed. Please this matter after 3 weeks. Mr. Sunil Mo, Learned Counsel for the petitioner, and Mr. Rama for the state respondents are present. Okay.
Obliged.
Item number 12.
May it please your lordship.
Yes, sir.
Lordship, may it please your lordship.
Yes.
Lordship, in this matter, lordship, we have taken steps on response number 7, 8, 9, and 10 by way of Dusty, and all have been served to all the respondents, lordship. We have filed an affidavit in that regard, lordship.
Okay.
But lordship,
When
in
did
this
file?
matter, lordship, the prayer for interim was kept open till the returnable date, lordship.
Proof of that. When did you file this compliance affidavit?
Lordship, this compliance affidavit was filed, lordship. I'll just check. Lordship, in the month of February, lordship, the Dusty was served. Thereafter, lordship, affidavit was signed. Lordship, in the month of February, we filed this affidavit, lordship.
No, as per office note dated 6/5/2026, that is
Lordship?
yet to be filed. Affidavit is yet to be filed.
Not yet filed.
Lordship, we had given for filing, lordship. I'll just
Okay.
check with that, lordship. If the matter can be taken up, lordship, next week in that case, lordship. Because, lordship, the prayer for interim is open, lordship, in this matter.
Okay. Miss
Lordship P. Borwa, my lord.
P. Borwa, Learned Counsel for the appellant. Some is that she has already filed a compliance affidavit after causing of service upon the respondent by way of Dusty. However, the same is not on record. The registry shall bring on record the affidavit filed by the compliance affidavit filed by the petition appellant. Staff, list this matter. When do you want?
Lordship, on Thursday, lordship. Thursday is 14th of May, my lord.
Next week.
Lordship.
Okay. Okay, 14th. This is matter again on 14th.
Deeply obliged, my lord.
Item number 13.
This is for lordship considering delay of 82 days, lordship, in filing the connected writ appeal, lordship. Mr. B. Picha was supposed to appear, lordship, for respondent, lordship. Correct.
No.
And I think this morning he was mentioning whether they have filed a wakalatnama or not. They have to check the records, lordship.
Objection.
Lordship, we have already filed the
Objection
wakalatnama.
not yet filed.
We have already filed the wakalatnama.
Okay, objection, they were to file objection. Not yet filed. This is for,
Considering delay of lordship, 82 days,
okay.
lordship.
Are you filing objection?
Lordship, I don't
Okay.
have.
You file objection within 2 weeks.
Within 2 weeks.
Okay. Mr. K. Loyal, CGC. For the applicant is present. Stop. Miss
Tia Big,
Lana Counsel appearing on behalf of
B Picha, Your Lordship.
Mr. B. Picha, Lana Counsel for the respondent number 1, 2, 3. Prayer for further 2 weeks time to file objection. The prayer is allowed. This matter after 2 weeks. Okay.
Deeply obliged.
Much obliged, Your Lordship. Item number 14 and 15.
May please, Lordship.
Yeah. So here, in this case,
May please, Lordship.
I recorded the evidence also. So this matter will be placed before any other appropriate bench. Hello, you are also not audible. Okay.
Am I? Hello. Am I? Ini the appropriate bench. Hello. Huh? Asil gini ni dia.
This matter before any other bench, the appropriate bench, without one of us. That is me, huh? Write my name. Okay.
I'm deeply obliged.
Item number 19.
It's a murder case, my lord. And my lord, earlier, she was appointed as a legal aid counsel for the victim family. She's not present today, my lord. For respondent number 2.
She's not there.
She is not present today, yes, my lord.
You are appearing for whom?
I'm appearing on her behalf. I'm legal aid counsel. She informed me just now that she won't be able to.
Okay, see, so you are seeking some time.
Yes.
Oh. So
Otherwise, my lord, we are prepared with this case, my lord.
With that, the victim's counsel has to be there.
Okay, ma'am.
Legal aid counsel has to be there. So you have any instruction when she would be, when it can be fixed?
No, still now.
But tell her to appear in the next date. I mean, legal aid counsel should not remain absent. It's a more responsibility than other lawyers, legal aid counsel. Once appointed by the court, an opportunity has been given to assist the court, then she or he should not remain absent. There's more responsibility on your soldier. Tell her, next date she should be there.
Lordship, next week, in that case.
Brother? Okay. Yes.
She should be there.
Very strong with you.
Or else, my lord, if she find difficulty, then my lord, my brother can pursue this matter because he's also a legal aid counsel. Next date, my lord. If she has difficulty, my lord.
In the first instances, legal aid counsel was appointed. Okay, it's a jail appeal only.
Yes, Your Lordship.
You are also legally.
Yes, Your Lordship.
The last occasion also she took time.
Yes, last time also she sought adjournment.
Okay. Okay. Amicus. Miss Ananju. For learned amicus for the appellant. Also had Mr. Ate, learned additional PP for the state respondent stuff. Mr. When she was appointed? By which order? Agent.
5/9/24.
5/9.
Yes, ma'am. Appointed with direction to the registry, my lord, on 5/9/24 by this honorable court.
So she has already received the paper book also?
Yes, my lord.
Then in that case, it will be difficult. Okay. The learned legal aid counsel for the victim is not present today. On his behalf, Mr. Ubori, learned counsel, prays for adjournment of the matter for the day. So when do we fix it?
Lordship, after a week, can it be on 21st?
21st.
Yes, Lord.
So next week she will be available.
She haven't replied me, but anyhow, I will instruct her.
Okay.
21st is Thursday, so dear
As
Steve,
prayed for, come at least this matter again on 21st.
21st.
Okay. Let us see. On that day, if she failed to appear, we'll have to appoint some other.
21st, Thursday.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item 11, my lord. My lord, we're supposed to file an additional affidavit. My lord, I'm requesting if my lord may kindly allow us
Yes,
one
yes.
more time to file the additional affidavit, my lord.
Okay, Mr.
E. Marngar, my lord.
Okay, learned counsel for the petitioner, prays for further. How much time is?
I'm for respondent number 3, my lord.
Who was to file additional affidavit?
Respondent number 3.
Okay, you are for petitioner. Okay. Learned counsel appearing on behalf of the respondent number 3, prays for how much time you said?
My lord, it can be listed on the 15th of this month, next week.
Prays for further 1 week time to file additional affidavit.
Yes, my lord.
Additional affidavit. Okay. To which Mr. Learned counsel for the petitioner has learned counsel appearing on behalf of learned counsel for the petitioner has no objection. Prayer allowed. List this matter after
On 15, my lord. Next Friday.
Friday. Will not fix on Friday.
All right.
Just a minute, huh? So this will be on 15, then 18. Okay. Is prayed for. List this matter on 18. Okay.
Highly obliged, my lord.
Number 1.
Yes.
Lordship, in this matter, Lordship, I'm challenging the order dated 28/11/2025, Lordship, whereby, Lordship, the petitioner has been dismissed from her service, Lordship. On the Lordship, may kindly come to the infing order, Lordship. Page number 26, Lordship. Page 26, Lordship. Annexure E. Lordship. Srimati so-and-so casual skill staff presently working in the office of the Assistant Engineer, Narlagan Electrical Subdivision number 1, Department of Power, Narlagan, under Narlagan Electrical Division, New Delhi, is hereby dismissed from her casual
Now, since then, you are no longer in service.
I beg your pardon, Lordship.
Since then, you are no longer in service.
Yes, Lordship.
Okay.
Now the Lordship, after issuing of this imping order, Lordship, I have made an inquiry before the department that why this order has been issued, Lordship. What happened, Lordship? I have been appointed on 6/1/2023, Lordship, after the expiry of my father, Lordship. Lordship, may kindly come to the page number 21, Lordship. The first appointment order, Lordship. Annexure B, Lordship. In the interest of public, Srimati Soin hereby engages casual meter reader unskilled in lieu of let Godak Tavio casual expire and posted under Nahalagan Electrical Department of Power Nahalagan with immediate effect. Lordship, after the appointment of this order, Lordship, I was working to the satisfaction of all the concerned, Lordship. Now what happened, Lordship? On 19/9/2025, Lordship, the one person, Lordship, who is the consumer of the electrical, Lordship, made an application addressed to the respondent number 3, that is the assistant engineer, Lordship, to issue an NOC, Lordship. Lordship, may kindly come to the page number. Simple application has made to the assistant engineer to issue an NOC, Lordship. And after that application, Lordship, I have been directed by the assistant engineer to check the records of that consumer, Lordship. And after, Lordship, may kindly come to the page. This is the case, Lordship, where there is no fault on my part, Lordship, despite the fact that, Lordship, I have been dismissed from my service, Lordship. Lordship, will kindly come to the page number 22, Lordship, Annexure C, Lordship. This is the type copy your Lordship will find at page number 23, Lordship. Prayer for issue of NOC, Lordship.
Yes, but see, in the sensitive issues, you have issued this saying that there was no bill.
Your Lordship,
but then
to clarify that, Lordship, Lordship, may kindly come
before issuance of this, your termination or discontinuation order,
Lordship,
they must have inquired, and in the condition in your appointment is the service is purely on casual. Appointment shall be terminated without assigning any reason if the performance of the duty is not found satisfactory.
That is correct.
The case where you have done something which otherwise the AE is also liable, would also be liable.
Lordship.
Because of your wrong information.
Lordship, I'm coming into that point, Lordship. Lordship, may kindly come to the page number 24, Lordship, for a moment, Lordship. Page number 24, Lordship, this is the screenshot where I have been taken from the computer, Lordship.
Right, yeah, but,
Lordship. The type copy is, Lordship. After entering the name of that consumer, Lordship, there was no bill was shown in the computer, Lordship. And that application for NOC, nothing has been stated that whether that person is going to be for the panchayat election or not, Lordship. Only simple for the NOC, Lordship.
Maybe Lordship. Even for the election, maybe for the normal also. Lordship. But then the report should be the correct one.
Yes, Lordship. Now, Lordship, may I kindly come to the page number 27, Lordship. Page number 27, Annexure F, Lordship. This is the bill which has been shown by the opposite party of that consumer, Lordship, during the time of scrutiny, Lordship. And Lordship, may kindly come to this date of bill period, Lordship. That is 1/10/2025 to 1/11/2025, Lordship. NOC was issued on 19 September 2025, Lordship. Right after the consumer made an application before the department, Lordship, we have issued an NOC, Lordship, after checking the background, Lordship. Now this application, naturally, Lordship, in the power department, Lordship, every month bill used to generate, Lordship. Now during the time of checking the background of the consumer, Lordship, there was no bill dues, Lordship. Now later on that after he was defeated, the consumer was being defeated in the scrutiny, Lordship, he made a complaint before the department, Lordship. There was a mislead has been there was a mislead information has been given to him, Lordship. There is no fault at all, Lordship, on my part, Lordship. Now, Lordship, so far as the legal point is concerned, Lordship, if this imping order, Lordship, issued just normally without any stigmatic or any stigmatic observation, Lordship, but the case could have been different, Lordship. Lordship, may kindly come to this.
Yes, anyway, so what we'll do? We'll issue notice or what? Will issue notice.
Lordship, in the meantime, I have the interim prayer also because I'm a divorcee, Lordship. Two minor children I have to look after, Lordship. There was no fault on my part, Lordship.
This impugn order was issued way back in
25. The reason being, Lordship,
How
I'm
do we
approaching,
stay?
Your Lordship, the reason being I'm approaching this honorable court so lately, Lordship, is that, Lordship, after filing of my representation to the engineer concerned, Lordship, that he assured that my case would be taken up after the financial year. That is the March ending, Lordship. Now, even after that, Lordship, they are not considering my application, Lordship, for consideration of my service, Lordship.
Okay. Heard Mr. T. Garu, Land Counsel for the petitioner. Also heard Mr. L. Perme, Land Standing Counsel for the Power Department. Staff, huh? The petitioner herein challenge the office order dated 28 11/20/25 issued by the executive engineer electrical respondent number 3, whereby his service as casual. What is your designation?
Casual, Lordship, meter reader, Lordship, unskilled.
Casual meter reader within bracket unskilled. Has been dismissed. For furnishing wrong information and misleading. Okay, dismissed. That's all. Dismissed for furnishing wrong information. Stop. Okay. Issue notice. Since Mr. L. Perme, Learned Standing Counsel, appeared and accepted notice on behalf of the all the state all the state respondent number 1, 2, 3. No formal notice needed. Issued. Stop. However, the petitioner shall serve extra requisite copy to the Learned Counsel appearing on behalf of the respondent during the course of the day. Staff, please this matter after 3 weeks. Okay.
Deeply.
Item number 2.
May I, Lordship?
Yes.
I am for the petitioner. This is a writ petition under Article 226. By filing this writ petition, I pray before your Lordship to stay my transfer order dated 27 March 2026, whereby I have been transferred from branch office Itanagar, Arunachal Pradesh to branch office Bihupuria, Lakhimpur, Assam, as branch in charge. Your Lordship, I received the impugn order during my undergoing medical treatment at Niba Hospital and TRIMS respectively through WhatsApp by the staff. Receiving the said order, I have submitted a representation before the respondent authority to retain the transfer order dated 30 March 2026 for the time being, but the said representation has remained unattended. Your Lordship may kindly see the page 16 and 17. It's a representation dated 30 March 2026.
Who are the respondent here?
Your Lordship, the Oriental Insurance Company.
Okay.
May I read the representation? To the Chief Regional Manager, Oriental Insurance, so-and-so, subject, written for.
Okay. Do you have whether this Oriental Insurance Company must be having some scheme for the transfer or some transfer policy?
Your Lordship, regarding.
One. What is the transfer policy according to the Oriental Insurance Company Limited?
Your Lordship.
How long one can be or kept or remain in one particular place? How long you have been in this place?
Your Lordship, there is regarding this policy, I have not been informed.
So you just better ask.
Your lordship, it's the,
You have been in Nahalagan here for more than 20 years.
yes, your lordship.
Okay, now it appears that your transfer has been done due to the administrative exigencies. So on
Your
that
lordship,
basis, you are challenging.
your lordship, I'm challenging on the medical ground, and also the transfer order was received through WhatsApp. It was given to me through WhatsApp by the staff. And also, I am also.
But later on, you must have received the hard copy.
No, your lordship, I haven't received the hard copy till that. And the representation I have submitted is still not considered by the company.
Is there any standing counsel for the insurance company? No. Do you know that if there is any standing counsel for the insurance company
Sir,
here in High Court? No.
Your lordship, it should be if the notice is issued to the company, they will engage one.
No idea. Okay. Will issue then, in that case, will issue notice?
Yes, your lordship.
Hard miss? Your good name?
Sangye Drama File. It's in the course list.
Okay. Sangye Drama File. Land counsel for the petitioner. Start, huh? By filing this writ petition, the petitioner challenged his transfer, challenged the order dated. By which order you have been transferred?
27 March 2026.
Okay. There is 27 March 2026 issued by who issued? Respondent number
1, your lordship.
1.
The chief manager of Oriental Insurance.
By which the petitioner is sought to be transferred from his present place of posting at BO Itanagar to BC Bipuria as BC in charge. Issue notice returnable by 4 weeks, returnable within 4 weeks. Staff, the petitioner shall take steps upon the respondents by speed post as well as by usual process within 3 days from within 3 working days from today. Staff, list this matter after 4 weeks. Okay.
Item number 3.
May I, Your Lordship? Your Lordship, matter may be passed over for some time. Counsel is in other court.
Okay.
Much.
Time being, huh?
Item number 4.
My lord, this item also pass over, my
lord.
Pass over, my lord.
Pass over for time being.
Timing, yes.
Okay.
Item number 5.
May I please, Lordship?
Yes.
Lordship, the petitioner before your Lordship is a land affected project landowners for construction of Trans-Arunachal Highway, double lane road from Thai to Gabu within Wecheng district, Arunachal Pradesh. What if, your Lordship, the petitioner's land was acquired by the government for construction of Trans-Arunachal Highway. While acquiring the land, the compensation was not free fair as per 2013 Act, LARA Act. Accordingly, being aggrieved of the same, the petitioner approached this honorable court by filing a writ petition challenging the compensation determined by the respondent authorities. And said writ petition was disposed of by order dated 8/2/2023, directing the respondent authorities to compute the compensation amount by including 100% solicium and land interest in the compensation amount. And same process to be completed within 2 years.
2 years.
Lordship, 2 months.
2 months.
2 months. Now, thereafter, Lordship, in terms of the Honorable High Court order, the Deputy Commissioner Alo prepared a additional compensation amount under new Act, LARA Act 2030, thereby enhance the compensation amount, additional amount of more than 5 crore by including 100% solicium and land interest, 12% rent interest for 4 years. Now, thereafter, Lordship, when the petitioner submitted the representation before the respondent number 1, 2, 3, 4 for early release of the compensation amount, they have issued a letter 3/10/2024, page number 41, Lordship. Page 41, Lordship. Regarding payment of solicium. With reference to the subject cited above, I am directed to inform you that as the matter regarding payment of solicium is sub judice before the Honorable Supreme Court of India by SLA number so and so and SLP number filed by the state of Arunachal Pradesh versus Mihil Laling and others, wherein a stay has been given and the disposal of SLP is awaited. Therefore, until the matter is disposed of by this Honorable Supreme Court of India, no further action can be advised in this regard. Now, this same connected in this state of AP versus Mihing Laling case, there was also challenge was regarding the payment of solicium and the land interest, Lordship. Now, the government of Arunachal Pradesh, by this communication letter, saying that the SLP before Honorable Supreme Court is pending. So, until disposal of the said SLP, no action can be initiated. Now, thereafter, Lordship, in the meantime, Honorable Supreme Court has disposed of the said SLP, saying that solicium and land interest should be paid to the landowners with a condition that if they have not received the compensation amount earlier. Accordingly, after disposal of said SLP, we have submitted another representation on 30/10/2025 along with the Supreme Court order, SLP order, saying that now Honorable Supreme Court has also disposed of, saying that for payment of solicium and interest, therefore, our compensation amount may be released. Now, said representation is still pending before the respondent authorities. So, at this stage, Lordship, my respectful prayer would be, direction may be issued to the respondent number 1, 2, 3, 4 for forwarding of said additional compensation amount prepared by the Deputy Commissioner in terms of the Honorable Single Bench order before the respondent number 6 and 7, who are the releasing authority, compensation amount releasing authority 6 and 7. And thereafter, Lordship.
Is it your pleaded case?
Yes, Lordship. Yes, this is my case, Lordship.
What is your, in the prayer, let us see.
Yes, Lordship. Page number 21, Lordship. 2-1. Prayer number 1. A direction may be issued upon respondent number 1, 2, 3, and 4 to immediately forward the additional compensation amount of rupees so and so, prepared and forwarded by Honorable Deputy Commissioner West Siang District Alo 5/10/2023 to respondents authority number 6 and 7. 6 and 7 are the MOT, Ministry of Highway, yes, Lordship. They are the releasing authority, Lordship. Now, prayer number 2. A direction may be issued to the respondent authorities 6 and 7 to immediately release the additional compensation amount in the event of forwarded by the respondent number 1, 2, 3, 4. Then prayer 3, direction may be issued to the respondent authority for early release, disbursement of additional compensation amount is entitled by the petitioners against the land acquired for construction of Trans-Arunachal Highway, Lordship.
So this additional compensation has also been received?
No, Lordship. This application, Lordship, in terms of single bench order, the deputy commissioner has prepared a additional compensation amount by only including the solicium and land interest. And they forwarded the said application additional compensation amount before the respondent number 1, 2, 3, 4, 5. On receipt of said additional compensation amount forwarded by the deputy commissioner, they have issued a letter saying that since the payment of solicium and land interest in compensation amount is pending before another case, Mihing Laling case is pending before Honorable Supreme Court. So let that matter be decided first.
Now that has been decided.
Yeah, that has been decided.
Now it is only on the part of the respondent.
Yes.
Forward.
For forwarding.
Yes.
It's my case.
That my lord has said earlier the writ petition was filed because the land acquisition was done under the June land regulation. Right?
Okay.
So the compensation amount was to be reasonable. That compensation was calculated, but the petitioners, they claim that the compensation should be calculated as per the LARA Act 2013. So that in that event, the compensation will increase the market value and all. So in the initial writ petition, when they filed, they said that we are not happy with the land compensation computed under the JLR. The computation should be under the LARA Act 2013. This honorable court, in the learned single judge passed by Justice Tagia, relying on Mihing Laling case, said that yes, the compensation should be computed under the LARA Act. Now, accordingly, the deputy commissioner has recalculated and prepared a new compensation under the LARA Act as per the direction of the honorable this honorable court. In the meantime, the secretary says that since the Mihing Laling case is before the Supreme Court, till the Supreme Court decides it, there no further action can be taken. Now that Supreme Court has decided dispose of the Mihing Laling case, the only thing now what has to be determined, Supreme Court also upheld that yes, all those beneficiaries whose compensation were calculated under the June land regulation, they are entitled to be calculated under the LARA Act, the solution interest and all. Now, only a rider was there. The Supreme Court's in the Supreme Court's decision that those concluded acquisition where already compensations have been accepted and it has been dispersed. This judgment, the Supreme Court's direction will not be applicable. Today, the petitioners, they are before this honorable court saying that since the further compensation has been, additional compensation has been prepared and it has to be forwarded. The only thing to be determined is that whether they have already received the earlier compensation. If they had received the earlier compensation, then it is a concluded acquisition and they cannot avail the benefit of this Mihing Laling case. But if they have not received, then they will be entitled. The only, so today, for today, notice may be issued and we will come up with an affidavit. If they have received, it will be a concluded acquisition. If they have still not received the compensation, earlier compensation also, if they have received it under protest also, they will be entitled.
Okay.
So that may be given that this we can clarify.
Okay. Mr. Lawrence, land counsel for the petitioner. Also heard Mr. N. Ratan, land additional AG. For the state respondent number 1, 2,
3, 4, and
3,
1 to 5.
1 to 5. And Mr. Kato, land DSG for respondent number 6 and 7. Stop. Para. The petitioners who claims to be project affected landowners for construction of Trans Arunachal Highway TAH double lane road from Tai to Gavu stream within bracket kilometer 226.232 to kilometer 338 dot 169 bracket close within West Siang district within bracket 14 to Pangin Road. Six, by filing this writ petition, seek direction to the respondent authority more particularly the respondent number 1, 2, 3, and 4 to forward the additional compensation amount. It's 5 crore or 50?
5 crore, Lordship.
Just come to your synopsis.
Lordship.
This seems like 50 crores. It seems some figure you have added.
Yes, Lordship. Lordship, I'm extremely sorry. Here, typographical error. Otherwise, Lordship, forwarding letter of
Okay, for the additional compensation prepared and forwarded by the Deputy Commissioner, West Siang District Alo, dated 5/10/2023 to the respondents authority number 6 and 7, and also to direct the respondent authority number 6 and 7 to release the additional compensation amount in the event of such forward being made by the respondent number 1, 2, 3, and 4. Staff for issue notice returnable by 4 weeks. Okay, staff, since Mr. N. Ratan, Land Addition AG, appeared and accepted notice on behalf of the state respondent number 1, 2, 3, and 4, and Mr. Kato.
1 to 5.
Sorry, 5 also.
1 to
Okay, 5, 1 to 5, and Mr. Kato for respondent number 6 and 7. No, the formal notice is waived. However, the petitioner shall furnish requisite extra copy to the Land Council appearing on behalf of the respondents during the course of the day. Staff, list this matter after 4 weeks.
May I amplify the Lordship? Can it be on 4th June? 4th June.
Okay, as
8
requested, list this matter on 8
June.
Okay.
Deeply obliged.
8 June. Okay.
Direction be against the
Pass over matter item number 3.
May I please, Your Lordship?
Yes.
My Lord, this matters related to a lane being used for firing range, my lord. That is called Balaliang Field Firing Range, used by Indian Army, especially located in Loyang, my lord. And that land is being used. That land belongs to community land, and SAM has not been acquired or no any compensation paid to the villagers for that particular land. There has been serious representation from the villagers saying that the land which you are using for the firing range, if it is not to be acquired or compensation is not to be paid, then it has to be restored back to the villagers, because that comes under the village agricultural Jumland areas. And then this range also passes is a range near to the village, and many villagers also has to go through that ranges And there are also many incident of live bomb explodes and many around 7 villagers were also killed. Now in this matter, my lord, I'll just take to the survey reports. Survey has been done, and then the deputy commissioner has been also asked to resolve the matter, my lord. A total area of 135 hectares, my lord. I'll just take to that a relevant page, my lord. Relevant page, my lord. I will take to my lord. Page 48, my lord. May I see the page 48.
Yes.
Page 48.
Yes.
Yes, my lord. Your lordship may see this. This is a joint survey of land at Balilian field firing range. And I will just take to the paragraph 2. Paragraph 2, serial number A. Your lordship may see this one. The legal status of the forest land proposed for diversion. They're on the process of diversion, my lord. And in the next column, your lordship may see approximate 135 hectares area of BFFR falls under non-forest reserve forest area, means it's a village land, my lord. And hectare 534 hectares approximate area is under the reserve forest area, has to be verified by the magistrate from the court. So this is the legal status of the land, my lord. So at least 135 belongs to the villages, and that has been illegally used by the army, 181 mountain brigade for the firing range, my lord. So, my lord, I'll just take to another important joint survey, my lord. That is in page.
So this also comes under non-reserve forest area.
Yes, non-reserve forest. Yeah, means
Not the reserve forest, but non-reserve.
yes, my lord. Non-reserve means basically.
But that also comes under forest area.
No, that will not come under the forest area, my lord. It will come under the community land, my lord. So community land can be covered with the forest or non-forest,
On
my
what
lord.
basis you are claiming that this land belongs to you?
Because this is belongs to the villages, my lord. It's located near to village. The village that's called Loilang village.
But then where is any document? So
My lord, there has been series of, my lord, I'll just take to another joint survey report, my lord. I'll just take to that one. That is the official document, my lord. Relevant paragraph one, I will just take to that one. Page 52. They have recorded that deputy commissioner has to, there has been complaint, there has been no NOC has been issued because there has been complaint and protest from the villagers, my lord. Page 52, my lord. Let me see that one. Page 52, my lord. Relevant, I will just take to relevant paragraph, my lord. Merit, page 52, field firing range at Balilian. Next, I can read just second paragraph. In the context of DC also informed that the house that Principal Secretary Home Government of Arunachal Pradesh has also sought clarification to this matter and directed DC Lohit to resolve the issue at earliest, but NOC can be issued for non-forest land after due consultation with the local inhabitants. Inhabitants as the firing point is located in close vicinity of the inhabitant area, unlike other districts. It is also informed that there is a severe resentment from the public. As a result, NOC could not be issued for the Balaling field firing range as of now. However, DC issued the house that local inhabitant will be convinced, and obtain approval of the state government soon for issue of NOC under national exigencies, So this is the situation, So, and Malad, I'll just take to the representations, Malad. Your lordship may see a representation, Malad. It's a series of representation, Malad. Complaint also filed, Malad. It's in page. Complaint, Malad. Page 26, Malad. Page 26, Malad.
We'll take his
Page 26 also a complaint, Malad. And then, Malad, page 26.
Since when this has been issued, used as the range of firing range?
My lord, pilot ranks has been issued for more than many years, my lord.
Many years.
Yeah, many years, my lord.
You came only in the year 2023.
Many years, my lord.
So will issue notice then in that case?
Okay, my lord.
Heard Mr. S. Maulani, counsel for the petitioner. Also heard. Miss.
Madam, time for respondent number 1, 3, 4, and 6. Madam.
Okay, Mr. Kato, Lana counsel, Lana DSG. Y for respondent number
1, 3, 4,
1,
and
3, 1, 3, 4,
and 6.
and 6. And Miss J. Lana senior, additional senior government advocate for respondent number 2,
7, 8, 9, 10, and 11.
7, 8, 9, 10, and 11. Staff, issue notice. Just a minute. Okay, by filing this writ petition, the petitioner seek direction to the respondent to initiate and complete acquisition proceedings in accordance with law in respect of 135 hectare of community, claimed to be community land forming part of BFRR. Part of within bracket BFRR within bracket Baliliang Field Firing Range bracket close. Lohitpur. Or in the alternative, to direct the respondent to vacate the said land and hand it over peacefully to the possession of, or hand over peaceful possession of the said land to the petitioners. Staff umpire, issue notice, returnable by 4 weeks. Staff, since both appeared and accepted notice on behalf of the respective respondents, the notice stands waived. Staff. However, the petitioner herself furnished extra requisite copies to the Land Council appearing on behalf of the respondents within 3 days from today. Staff. List this matter after 4 weeks.
4 weeks.
Okay.
Madam, this is one correction. Madam. In respect of respondent number 5 also, madam. I'll appear, madam.
Okay, 5.
Five,
Also.
five,
five.
DSC, so 5 also. Okay.
No difference to public.
Level matter item number 4.
Yes.
My lord, in this matter, my lord, I think without entering into marriage, my lord, the notice can be issued, my lord. This basically, my lord, it seems that as per advertisement, my lord,
They did not come. They were not eligible.
Yes.
At the time of appointment.
Yes, at the time, because as per advertisement, one of the
Requirement
of education is that one has to be a degree in special educator.
Which they were not.
At that point of time, they did not contest.
But subsequently, they have acquired.
During the 4 months, that document that submitted that found to be fact. On the basis of the fact.
The subsequent, the documents,
when they
that also fact.
Yes, they were in service. Subsequently, they have acquired.
What about the others?
Others,
They otherwise have
they
acquired.
not acquired. But some of these petitioner, they have acquired during their in service.
Yes.
Now the question is whether the qualification they acquired after appointment, because appointment was done based on
based on those certificate requirement. Okay.
So having
but then subsequently you have extended or you have renewed
that part.
Yes, ma'am.
So that was subsequent renewal, at the time of subsequent renewal, probably this application, this certificate that they have acquired subsequently
That they have,
probably have been submitted to you.
my lord, my lord. That part, they have considered, authority, they have considered it since the initial.
Appointment was,
that
okay.
were,
Okay. We'll issue notice then.
Yes, that
You file
we can
affidavit.
let
Okay.
them- Let that come up with the detail, by the department.
Okay. This is item?
Item 4.
Heard Mr. T. Naga, learning counsel for the petitioner. Also heard Mr. T. Tagum, learned standing counsel for education department. Okay. Where is the impugn order?
Impute order is page 316.
This writ
316.
Okay, by filing this writ petition, the petitioner, how many, 18?
15.
15
Yes,
in
15.
numbers. Okay. Challenge the page?
Page
Okay.
316.
316.
316.
316.
Challenge the impugn order dated 6/2/2026, whereby
Along with petitioner, altogether 41 members.
okay. What was their post?
The petitioner's post is resource.
Okay. The service of the petitioners along with others have been terminated. Is termination?
Yes, termination, terminated.
This is a contractual only?
Contractual.
Yes, contractual.
Service of the petitioners along with others have been terminated. Huh? Will not submit, not record your submit because your submission, because your submission is only that subsequently they have acquired. That will not record at the moment. Okay. The issue notice. Since Mr. Tagum, Plan Standing Counsel for Education Department appeared and accepted notice on behalf of the respondent number
1, 2, 3.
all the respondents. Number 1, 2, and 3. No formal notice need be issued. However, the petitioner shall furnish extra requisite copy to the learning counsel, Mr. Tagum, during the course of the day. Staff, para, list this matter after
4 weeks.
After 4 weeks.
My lord,
Or 3 weeks.
Yeah, 3 days.
Okay.
My lord, it can be subject to the outcome of the writ petition. Observation.
Okay. The having regards to the contention and the submission made by the petitioners, it is provided that the termination of the contractual service of the petitioners shall be subject to the outcome of this writ petition. Okay. Subject to the outcome. Okay.
Oblige. Duly oblige.
Item number 6.
My lord, this item can be disposed of today.
You were to file rejoinder probably.
Rejoinder is I have filed my reply affidavit, and they have filed another additional affidavit. My lord, it may not be required also, because they have only carried out the verification, and they have given that information that there are 12 high-rise buildings in and around the ALG Pasigat.
This is against the order issued.
My lord, some kind of an injunction order issued by the state officer. Selective injunction, my lord. Now, can it be taken up for disposal, my lord?
Can it be?
No, sir, because this is, the petitioner's building is within 15 meters of the ALG. Advanced leveling.
Okay. It's a high-rise building.
Also, even if it is not high-rise building, also, it is not allowed within 15 meters. The maximum is 100 meters. And the petitioner is within 15 meters.
Okay.
And
My lord, may I just, in that case, may I just start?
Just a minute. So, just a minute, huh? You have filed affidavit.
Affidavit, I have filed my reply affidavit. They have filed additional affidavit as directed by your lordship.
So, no, so since she has an objection, it may have, we may have to, I think, fix for hearing then if both are ready. We'll have a separate hearing there. Or what? You think that can be disposed of?
It will take some time. It will take some time.
So
It
that
will
is
take
why.
at least 1 hour. So can it be next week then?
Next
On
week?
12th or 13th?
Whether the other persons, who's according to you, whose lane also falls within, have also filed any.
No, they have not been issued any notice. Only me and one another person. And that is our case. We have shown the photographs also, the high-rise building
It is
around.
not a case for the matter to be decided by the civil court, because we do not know the ground reality.
My lord,
The High Court.
my lord, that is second part of this thing. Our challenge is only to that selective notice, because we are not ours is not, mine is not unauthorized construction.
Even the photographs are also not available, because this concern with the ground level factual dispute of the fact probably, because what you are saying is it's a selective.
My lord, yes, my lord, we as I've submitted, that would be the second part. If the government desires to do that, they can always go for eviction and then cancellation, whatever they may.
Okay.
That is the first part.
Okay.
I am challenging only the impugn or the injunction order. So
injunction to restrain you from further
construction. Whereas I have already constructed the building.
See again, facts count.
And actually the permissible height is 7.08 meters. That is equivalent to 23.22 feet. But restriction is ground floor. But what I have done is I have constructed my building at the height of maximum 11 or 12 feet, because from the base and then on the this thing, top
roof. Okay.
Roof. The middle portion is about
only
10
ground floor.
Only ground floor, as permitted by the authorities.
Not even the first floor.
No, mine is not a high-rise building.
Okay.
We can just take it up on I don't know, on 13th.
When do you want? Okay. So it will be listed as a for hearing.
admission hearing.
Admission hearing. Okay. Heard Mr. T. Pertin, Lana Counsel for the petition. Also heard Ms. G. Atta, Lana Additional Government, Additional Senior Government Advocate for the State Respondent. Stop the prayer of both the Lana Counsel for the parties. List this matter again on. When?
28.
28. Okay.
Because 26 there will be division bench, and 27 will be an holiday.
Yes. Sir.
That will be on 28. Admission hearing.
Okay. 28 is Thursday again.
Yes, Thursday. we don't.
No, Thursday, eh?
No, division.
With DV day.
Oh,
29.
29 is Friday.
Okay. Then 8 June.
Okay.
8 June. Okay, for admission hearing.
8
Okay.
June, 8 June.
Next day, 8 June or
No, let it be on 10.
not 8 June.
10 June.
First June. First or
Ha, Malat.
1st June.
1st June.
Okay.
That is Monday.
Okay.
Obliged.
Item number 7 to 9.
My pleasure, Your Lordship.
Yes.
Malas आइए मतलब
I
is for impleadment of respondents, my lord.
Okay.
Malas item number 7, my lord. Item number 7, my lord. We wanted to implead 5 and 6. Item number 7, IN 94.
Okay.
We wanted to implead respondent number 5 and 6. 5 and 6 is
Who are they?
Airport Authority of India, and
No
second.
objection?
No.
Okay.
There are 3 IAs, madam.
Okay.
All Airport Authority of India and Ministry of Civil Aviation.
Item number IFO 94, 95, 96.
Okay.
In all 5 and 6.
5 and 6. Okay. Heard Mr. Sunil Mo, Learning Counsel for the applicant. Also had Mr. N. Ratan, Learned Additional AG for the state respondent. Stafa Kar. This application, by filing this application under Order 1, Rule 10 of Civil Procedure Code 1908, the petitioner is praying for impleadment of the Airport Authority of India, within bracket AAI, and the Ministry of Civil Aviation, Government of India, as respondent number 5 and 6, respectively, in writ petition number WPC 107 AP 2023. On the ground that they are necessary party, and if any compensation is to be paid, then the same has to be paid by the said two authorities. Stop. The prayer having not been objected to by the Land Council appearing on behalf of Land Additional AG for the state is allowed. Stop. Accordingly, the airport authority, the Airport Authority of India and the
Ministry of Civil Aviation.
Civil Aviation, Government of India, has mentioned it. Is be impleaded as respondent number 5 and 6 in the aforesaid WPC 107 AP 2023. With the above, this IS stands allowed and disposed of. Okay. Then in the main,
Madam, that post title may be.
in the main, we'll say.
Main.
Heard Mr. Sunil Mohan and both, after hearing both. So in view of the order passed today in IA C 94 AP 2026, the board the authority again, the airport authority, the Airport Authority of India, AAI, and the Ministry of Civil Aviation, Government of India, are impleaded as respondent number 5 and 6, respectively. Staff, the petitioner shall amend the cause title by inserting the name of the newly impleaded respondent number 5 and 6 within a week from today. Okay? Staff, and so notice after that. Okay, list this matter after. When?
After 2 weeks, my lord.
After 2 weeks. Then similar order in other also?
Similar orders.
Same?
Same, madam.
Okay.
For the respondent, in the other 107, 108 and 109, respondent will be separate, 6 and 7. In both the
Okay, then in item 7, it will be 5 and 6,
Yes.
The newly impleaded. And in item 8, it will be 6 and 7.
Yes, 6 and 7. 8.
Okay. Authority same.
Authority same.
Okay.
And other 9 also.
8 and 9, I'm saying.
8 and yes, 8 and 9 will be 6 and 7. Yes.
Okay.
Authority same.
Okay.
Publish.
Are you disposed, Okay.
Item number 10.
Wait, please. Yes, I am assisting simulated book.
Okay. So,
Lord,
IA, you have filed IA?
yes, I have already filed.
Impleadment. Will
Yes, ma'am.
implead?
For impleadment of the respond number 6, my lord. The wife, first wife as a respond number 6.
Well, since parties are appearing, KB disposed of yesterday or what?
No, no.
Not yet. Okay. Since the caveator appeared on the through their learning councils, the caveat stands disposed. Okay.
My lord.
Then this is IA only. That is caveat. Okay. Then hard Mr. Okay, Kaushik, Mr. B. Kaushik, Land Counsel for the applicant. By filing this interlocutory application, the applicant pray for impleadment of Srimati Toko Yaju, first wife of the petitioner, as the party respondent number 6 into the petition number 194 AP 2026. See, your name also will be recorded, okay? Hard there, Mr. Tamafo.
No, madam. I am assisting Majumdar, sir.
Okay, sorry.
Madam, his name may be recorded, no difficulty, my lord.
Okay, Mr. Who is the
Thomas.
respondent number 1? No, just a minute,
1.
1, 4. Okay. Okay, Miss Manju for respondent number 1, 2, and 3. And then director is
Okay, Mr. J. Ginny for the respondent number 4 and Mr.
Matlab 5 also
Majumdar.
I have made the director by name. Matlab.
Director by name.
Yes, because I'm alleging malice against him.
Okay.
Malafide against him.
Mr.
Note.
D. Majum, Line Senior Counsel, assisted by Mr. Tama for the caveators. Caveator. Okay. Stop. Then after that, the prayer having not been objected to by the Line Counsel appearing on behalf of the respondent is allowed. Stop. Accordingly, Srimati Toko Yajur, wife of Sri Mai Guru Kamdir, is impleaded as respondent number 6 to the writ petition number so and so, 194 AP 2026. Stop. With the above, this IA stands allowed and disposed of. Okay. Then in the main part, Mr. Kosik, Line Counsel for the petitioner and all those parties. Okay. Now, and all those parties, including Senior Counsel Majumdar and Tama also. Okay. So in view of the order passed today in IA number 97 AP 2026, Srimati so and so, same thing, is impleaded as respondent number 6. Stop. The petitioner, the petitioner shall
194.
file amended cause title by inserting the name of the newly impleaded respondent number 6, newly impleaded Srimati so and so, as respondent number 6. Stop. Within.
But during the course of the day, I can.
During the course of the day.
I can.
Okay. So then.
Matlab, as I'm praying for an interim, Matlab, and Matlab, apparently, Matlab, I have projected a case, Matlab, where I have made out that the order which has been put under challenge is in violation of principles of natural justice. Whether there were complaints, Matlab, that is immaterial, Matlab, because the complaints have not been inquired into by giving me an opportunity of being heard. So, prima facie, Matlab, this order is non-honest in the eye of law, Matlab. Secondly, Matlab, if the fact-finding committee's report has been a basis for this order, then, Matlab, your Lordship has seen that when the notice of fact-finding committee was served upon me, immediately on the next day, I have informed to the director that I am not available. I am on leave and I am undergoing a treatment in Delhi. So, necessarily, Matlab, the fact-finding committee ought to have given me an opportunity of being heard by fixing another date. But the fact-finding committee, Matlab, I don't know what recommendation has been given against me, but the director, on being even demanded, Matlab, has refused to give me the recommendation. Your Lordship knows, Matlab, even in an inquiry, Matlab, I am the person against whom a proposed action is sought to be taken. He is entitled for the inquiry report. So, Matlab, apparently, Matlab, the entire action that has been taken by the authorities are in violation of principles of natural justice. So, Matlab, my apprehension is that based on these actions, any coercive action can be taken against me. So, Matlab, at this stage, what I am praying is, Matlab, the moot question which will require your Lordship's consideration herein, Matlab, primarily because I have challenged the order on the basis of violation of principles of natural justice, that whether prior passing of this order, the impugn order, whether a inquiry was made with regard to the veracity of the allegations made in the purported complaints by the respondent number 6, whether a notice has been served upon me by supplying the copies of the complainant, Matlab. These are the two primary questions, Matlab, the authorities has to answer, Matlab, to withstand the legal scrutiny in respect of this, Matlab, the impugn order, Matlab. So, Matlab, what I am praying is, Matlab, in fact, Matlab, the respondent number 6, Matlab, yesterday, as has been made a submission was made. Matlab, she is a complainant, Matlab. Matlab, that's why I was opposing to it, and that was the purpose of not making her a party in the writ petition, Matlab. There's a clear-cut judgment of our Honorable Supreme Court, Matlab, which clearly says complainant can be at best a witness. She cannot have assume the character of a litigant, Matlab.
what the land council, council has submitted.
No, no, but-
She's a wife.
Yes,
And definitely, when the
granting of permission.
second wife is enlisted, or second wife is allowed to be enlisted in the service book, then automatically there will be a dispute between the first wife
That's
and the
that's
second
not
wife.
the Malad, that's
It will
not the
affect her.
Malad,
That is
Malad,
need to be impleaded.
as on today,
Hmm.
that incorporation in the service book has not been done. That's not a cause of action, Miller, at all.
Okay.
Though what cause
But
of
then
action?
she apprehends. That's
See,
probably.
yes, she is a party now. Miller, now whether any coercive action can be taken against me or whether would be taken against me, it is an administrative decision which has to be taken by the authorities, Miller.
Okay.
There, my lord, in my respectful submission, the wife will have no say. My lord, there's a judgment of the Honorable Apex Court which clearly says that complainant cannot assume the right of a litigator, my lord. She can at best, in an administrative law, in an administrative decision, she can at best become a witness. So even tomorrow, whether the authority would proceed against me for taking note of this fact-finding committee's report, that is a decision to be taken by the authorities. So, my lord, what I apprehend, my lord, as an action has been done, has been proceeded to be taken against me without giving me any opportunity of being heard by the director, my lord. So, I apprehend, my lord, the director may use these reports as a tool to take coercive action against me. So, Lordship will protect me. Let the authorities file their affidavit even the respondent number 6 will also file their affidavit. My lord will take up this matter on 1st or 2nd of June for final disposal. Till that time, my lord, no coercive action may be taken against me. That's my limited prayer, my lord.
So will issue notice?
Well, I've got only one submission to make. Notice will go certainly, my lord, and Lordship will fix a date for final disposal. In the meantime, my lord, two things are necessary. The state respondents may be directed to produce all records, particularly the complaint filed by our client, my lord. None of the complaints have been annexed, number one. Number two, my lord, since the respondents, particularly the director, is also party here, director will produce the records so that the Honorable Court can take a proper decision, my lord. My second submission would be, so far as the prayer for
Director
of Neris,
to produce. Director to produce.
Yes, to produce the records and file affidavit in support of the. My lord, my second submission is, my lord, as far as the prayer for stay is concerned, my lord, the impugned order has got two legal implications now. One, if this order remains and the permission which was granted for the second marriage is cancelled, then possibly immediately the petitioner cannot bring the second wife at home or cannot stay with her. This is the prayer of our client. Second aspect of the or the consequence of the impugned order is that if this remains and if there is a second marriage without permission, then it amounts to misconduct in accordance with the Central Civil Services Conduct Rules 1964. So, so far as petitioner respondent number 6, I think, for whom we are appearing, my lord, is concerned, she is definitely interested to see that no exemption is granted and the petitioner cannot marry the second lady, my lord. But so far as the first part is concerned, my lord, although there is a prayer for interim stay, because if this impugned order remains, there is a possibility that the authority will start a disciplinary proceeding because the second marriage becomes my lord, misconduct without permission. Now here I'll pause for a moment, my lord. Even before this permission was granted, my lord, on 24th of June 2025. But the petitioner has suppressed certain documents, one of which is very, very relevant, that earlier the petitioner himself had sworn an affidavit. And in the affidavit, he clearly admitted that the second marriage had taken place in the year 2023 itself. Wait. My learned friend, yes, my lord. The second marriage, he has sworn an affidavit earlier, and in that affidavit, he himself has made a statement on oath that he had married on 28/12/2023. My learned friend will furnish a copy of this document to your lordship. This they have not annexed, nor they have made any reference of this in the writ petition. So this document being very relevant, there is a suppression of material fact, my lord. This document, if your lordship has seen, my lord, it is an affidavit by the two persons. By
page 92.
That the marriage took place in 2023. So even if that impugn order is stayed, this document is there. Based on this document, disciplinary proceeding can always be initiated. So the prayer that, my lord.
Yes.
So, my lord, the prayer that unless this impugn order is stayed, there is a possibility that authority will take coercive measure. That coercive measure can be taken even without this document of impugn order based on this affidavit. It's a sworn affidavit. And there you have admitted that marriage took place in 2023 itself, much before the permission was taken. Either way, the apprehension of a disciplinary proceeding being initiated against the petitioner will remain. And there is no challenge to this affidavit. There is no discussion, there is no reference, there is no disclosure of this affidavit in the writ petition. This is one submission.
This affidavit was submitted before the authority earlier.
Yes, my lord.
Before marriage officer Anini.
Okay.
Before the marriage officer Anini.
It is available with the authority.
It is available with the authority. It's a part of the proceeding. My lord, it is true that the findings of the inquiry committee should have been submitted, the report should have been furnished to the petitioner. I also agree to that, my lord. But then these reports are there, petitioner is aware of these reports. These reports which are directly against the petitioner were not incorporated in the writ petition. And the complaints which were submitted by the petitioner, if your lordship sees that complaint, I do not know where is that 22nd of September 2025, the petitioner submitted a detailed, this respondent, service number 6, submitted a detailed complaint mentioning everything there. And this has not been produced. And there are allegations that the permission was obtained by forcing the director. And they are now alleging malice in fact against the director, but the director is in collusion with the petitioner. Director has issued the certificate, my lord. The additional Advocate General of Arunachal Pradesh has subsequently given his opinion, differing with the opinion given earlier by the Standing Council, and he mentioned two things. One, the permission or exemption which was granted under Rule 21 of the CCS Conduct Rules 1964 is to be given by the government, because since it is a central rule, it mentions central government, and government of Arunachal Pradesh has adopted this rule for all practical purposes. So it will be the state government. It clearly says that Rule 2 reads like this, my lord: no government servant having a spouse living shall enter into or contract a marriage without any person, provided that the central government may permit a government servant to enter into or contract any such marriage as is referred to in clause 1 or clause 2 if it is satisfied that condition A, condition 2. So director has got no competence and no jurisdiction to grant this permission. The petitioner, by asking for a stay, is praying that the permission initially granted should be for the time being kept valid so that no coercive action is taken against him. But the director has got no authority under the law to grant such permission. It is the government. And since director, we have written several times before the director and other authorities. Since no action was taken, we had to approach the government. It is because of the intervention of the government that now all these actions have begun, and there is a withdrawal of the permission which was obtained without pointing out or without bringing to the notice of the authority the actual fact, including the fact that he has already married before this permission was sought, and the objections raised by the present respondent number 6. And rule is very clear. Rule is very clear. Rule says that the permission, this exemption can be granted not only because it is permissible under the personal law, but also there are other grounds for so doing. So in this, in my humble submission will come whether there is any objection from any person. If there is an objection for the existing wife, whether that should be taken into consideration. These were not taken into consideration. So on all these grounds, Madam, I am submitting that possibly the petitioner is not entitled to any interim protection because of the suppression of material fact, and also because that the permission based on which the permission which was granted is ex facie illegal for incompetence of the authority which granted. Director has got no power under the rules to grant such exemption. It is the government. That is my submission, Mr. Lord.
Well, may I just quickly respond to this, my lord? My lord, the first objection which has been said that none of the complaints were annexed, my lord. My categorical case is that I have never been served with this complaints, my lord, which has been referred in the impugn order, my lord. That's my categorical stand. Your lordship will kindly come to paragraph, my lord, 20.
But I'm just quickly making one mention. Director, the present petitioner is the registrar, and he is in possession and in custody of all the documents are in his custody.
Lordship will kindly come to page 19, my lord, of my writ petition, my lord.
Okay.
Page 19, paragraph 21, my lord. That the impugn order dated so and so, on the other hand, also refers to certain complaints made by the estranged wife of the petitioner as the basis for cancellation. Permission accorded by 24(9) in consequence to the approval of the competent authority. But surprisingly, the petitioner was never served with the said complaint so as to afford him an opportunity of being heard or to respond to the veracity of the purported allegation in such said complaints. It is a settled position of letter, no one can be condemned unheard, and yet the impugn order was passed basing on the complaints without any inquiry and without affording any opportunity of being heard. Above apart, impugn order is also mentioned that the earlier permission was accorded without proper verification of material facts, including non-disclosure of prior solemnization of marriage and absence of prior permission, though the said findings are perverse, unilateral, and absolutely incorrect, having no iota of truth. My lord, I have denied this, that there was any prior solemnization of marriage. In fact, my lord, the FIR which was lodged by the respondent number 6, my lord, the same issue was raised before in the investigation, and the final report has been submitted by lord. I have given this final report. The charge sheet, my lord, it is the statement of the respondent number 6 before the investigating authority was that I entered into an wedlock with the second wife and had applied for a marriage registration certificate based on that purported affidavit, which I'm denying it. That affidavit, I'm denying it. And your lordship will kindly come to page 7, my lord, of that charge sheet, my lord. There is a categorical finding of the investigating authority that after examining the deputy commissioner of the Anini Dibang Valley, my lord, that the allegations of the complainant are baseless. Paragraph page 7, my lord, to kindly see, my lord. This is the charge sheet in the police case that was lodged by the respondent number 6, my lord. Page 7, second paragraph, my lord, kindly see. A requisition under section so-and-so was served to the Deputy Commissioner Anini to authenticate the allegation of the complainant regarding marriage affidavit. My lord, finds?
Yes.
The reply received from the authority stated that no prior process took place between the alleged accused and Miss Yumri Ram. Hence, the allegation of second marriage by the complainant does not stand. So, my lord, there is a finding of fact by the investigating authority. Now, necessarily, my lord, your lordship is exercising a power under Article 226, where your lordship will not go into the disputed facts, my lord. Lordship has to see whether the decision-making process is correct or not.
Okay.
So, my lord,
Hard, Mr.
My lord, one more thing, my lord.
Hard, Mr.
My lord, one more clarification, my lord. My lord, my learned senior has said the director has got no power to grant this permission, my lord. Now, my lord, your lordship will kindly come to page 97, the impugn order, my lord. Director issued the permission, order of permission based on the approval given by the chairman, my lord, of the board. Page 97, last paragraph, my lord, you can see. Whereas it has been observed that the office order dated 24/9/2000 is not in consonance with the approval accorded by the chairman.
Chairman is not the government, my lord.
Well, that's an issue, my lord. Your lordship will decide whether the permission is properly done or not done. My challenge in the writ petition, my lord, I am placing one judgment of the Honorable Supreme Court, my lord, where, my lord, I would like to place, my lord, what is the status of the respondent number 6 in an administrative process, my lord? My lord, may I just place this 3 paragraphs from this judgment, my lord? 32, 37, and 44, my lord. 37, my lord, I am relying on the malice in law, my lord, because it is an authority's order which I am putting to challenge, my lord.
See, it's a notice period. Para?
My lord, paragraph 32. 32, my lord, will kindly see it's regarding principles of natural justice. Apparently, when, my lord, the prima facie, it is a case, my lord, which I have made out that there is a gross violation of principles of natural justice. Your lordship will kindly see paragraph 32, my lord. It has been held that the object of the underlying rules of the natural justice is to prevent miscarriage of justice and secure fair play in action. The expanding the horizon of principles of natural justice provides for requirement of records reasons as to now regarded as one of the principles of natural justice. It has been expanded, my lord. Now, lordship will kindly see, my lord, what injustice has been meted to me, my lord. Your lordship will kindly appreciate that. And the prayer which has been made by my learned senior that the first wife wants that the second wife should not come to the house. Well, it's not a matrimonial dispute your lordship is deciding, my lord. The permission was accorded on 24/9/2022. Rightly, wrongly, my lord, there was a permission. That permission specifically mentioned to proceed with the second marriage. Now, my lord, accordingly, on 10/10/2025, second marriage has occurred. The customary marriage has occurred. Now, my respectful submission before your lordship is that now, by virtue of this withdrawal of the permission, what would be the status of the second marriage, my lord? What would be the status of the second wife, my lord?
No, married probably, which was
after the permission
on 24/6/2025. No, 23. Way back.
No, that is disputed, my lord. I am disputing that I have never married.
You are going to enlist her name in that service. That pose a problem.
Lordship
Anyway, we'll issue notice. Okay. Hard, Mr.
My lordship, I'm categorically making a
Since
prayer
I'm
for
the
entry.
caveat here also, lordship, since the caveat has been disposed of,
Yes.
I'm representing the director, lordship.
Yes.
Is contented, lordship, I'll be requiring some time to produce all the relevant documents
Okay.
regarding the complaints and all, lordship. Lordship, 1 or 2 points that's just I wanted to highlight, since they have alleged malice against me, lordship. Here, lordship, since all those complaints that was filed before us as well as before the higher authorities, lordship. Lordship, may kindly come to page 87 of their petition, lordship.
I wanted to point out that paragraph of the judgment, my lord. Paragraph 44, my lord. But I'm sorry. Because a lot of indulgence has been given to the complainant wife, my lord. And therefore, my lord, I'm placing this judgment, paragraph 44, my lord.
Yes.
So and so, ex-president was the complainant. Thus, at most, he could lead evidence as a witness. He could not claim the status of an adversarial litigant. But this is what a prayer has been made, my lord. The wife doesn't want the second wife to come to the house. The wife wants the disciplinary proceeding to occur. The complainant cannot be a party to the lease. The legal right is an avertment of an entitlement arising out of law. In fact, it is a benefit conferred upon a person by rule of law. Thus, a person who suffers from legal injury can only challenge the act or omission. There may be some harm or loss. My lord, kindly mark this. My lord. There may be some harm or loss that may not be wrongful in the eyes of law, but it may not result in injury to a legal right or legally protected interest of the complainant. But jurisdically, the harm or description is called daemon sine injuria. The complainant has to establish that he has been deprived or denied of a legal right and he has sustained injury to any legally protected interest. In case he has no legally pegged for a justifiable claim to hang on, he cannot be heard as a party in a lease. The fanciful and sentimental grievance may not be sufficient to confer a locus standi to sue upon an individual. There must be an injuria and a legal grievance which can be appreciated and not step pro volunteers reasons and claim devoid of reasons. Under the garb of being necessary party, a person cannot be permitted to make a case as that of general public interest. A person having remote interest cannot be permitted to become a party in the lease as the person wants to become a party in the case. He has to establish his proprietary right has been or threatened to be violated for the reasons that a legal injury creates a remedial right. So, my lord, in this aspect, my lord, why I'm making a submission, my lord, I am claiming that my legal right of principles of being heard, my lord, opportunity of being heard has been violated, my lord. And my lord, I'm categorically praying for an interim order, my lord. Therefore, my lord,
Yes,
the
what is your sense?
lordship will consider.
If lordship is
Short.
My lord,
lordship,
page
page
87 is, my learned friend is pointing out page 87 that may kindly be seen, my lord.
Now, this very letter was directed to the director to initiate action in regards to the complaint that was filed by the respondent number 6 in this instant case. Forwarding of complaint of Srimati Tokoyojur, wife of so-and-so, narrates for appropriate action. I am directed to forward a representation dated so-and-so received from Tokoyojur, wife of M.K. Kamdar, registrar Nerist, Nirjuli, Arunachal Pradesh, alleging for extramarital affairs and harassment against her husband for your necessary action. This issue is with the approval of the competent authority. Lordship, as per this letter directed to me from the Ministry of Education, Government of India, Lordship, I had to initiate certain actions against the petitioner, Lordship. Accordingly, that fact-finding committee was constituted. And equally, I have been instructed that he was given the opportunity. They are admitting that fact that the opportunity was given, Lordship.
Okay.
Date was fixed. He willfully did not appear before the fact-finding committee.
Okay. Heard Mr. V. Kaushik, Land Counsel for the petitioner. Also heard the same party, huh? Okay. And you for the 1, 2, 3. Then there are the director and I'm senior counsel for the respondent number 6. Caveat 6. Caveat. Stop. Paris. Petitioner has challenged the order dated 24/9/2025. Whereby permission. No, not 24, 17/4/2026. Whereby the earlier permission, the earlier order dated 24/9/2025, whereby the petitioner was granted for contracting second marriage under section 21(2)(a) of the CCS within bracket conduct rules. Has been cancelled. cancel. Stop. Para. It is submitted that based on the complaint lodged by his first wife, the aforesaid order was issued. However, the complaint, despite of being requested was not furnished furnished by the respondent.
Well, I have no knowledge about this complaint, Malad. I did not request for this complaint. because-
Thereafter, you have made a request that you said.
No, I made a request with regard to the report of the fact-finding committee.
Okay.
This was never within my knowledge, Malad, that there were some complaints with regard to the permission, Malad.
Okay. Then
Lordship, I'm instructed that report of the fact finding committee, it has been submitted to the government of India accordingly. Since that instruction,
okay, based on the fact finding report.
yes, that
It was
that has been submitted before the government of India, Lordship, Ministry of Education.
But that's
Since that
there
instruction,
in the writ petition, Malad. In fact, when I asked for the fact-finding committee's report, the director said that I cannot give it. It's confidential. It is submitted before the government.
Okay.
since that order which I have read it out, Your Lordship, that order clearly give me the directions to initiate certain action against the petitioner herein. Accordingly, that fact finding committee was constituted.
Petitioner
A report was prepared and then accordingly submitted before the ministry concerned.
Before
He
issuance
can
of
approach
the-
the ministry and he can avail that copy from there.
impugn order, no opportunity was afforded to him. Stop, huh? And accordingly pray for the interim prayer.
Malad.
Okay, stop. However, the Planning Council appearing on behalf of the respondent oppose the interim relief. Stop, huh? There are having and submitted that opposed the interim relief on the ground that the respondent, sorry, the petitioner has already contracted marriage on 12/2023,
And that is the basis for constituting fact finding.
already contracted second marriage on 28/12/2023 prior to obtaining of the permission
Dated 24/9/2025.
on 24
9.
9/2025. Stop. Per issue notice. Returnable by.
I would also take note of that Malad, final report which I have said, Malad. Because that Malad, this is a document which has been handed over by them now. So Malad, Lordship will also take note of my
regarding criminal case.
They are also the same allegation, Malad, that I have contracted a marriage.
Annex it in the petition.
Malad, that the allegation which they have brought that showing an affidavit, Malad, which has been said that this affidavit does not hold.
No, whether this is a final report.
Yes, this is a final report. Charge sheet.
It's a charge sheet only.
Yes, Malad.
Not yet proved.
No, not yet. But that affidavit, Malad, whether it is proved, Malad, Lordship will take note of an affidavit which I have denied, Malad.
That affidavit which was part of the complaint. This is
No, it's not part of the complaint, Malad. That's absolutely incorrect, Malad. It was never
part of the complaint of the petitioner number respondent number 6.
Malad, that was never been given to me.
That was
Malad, that was never been given to me, Malad.
Okay. Having regards to the nature of allegation made against the nature of allegation and the material placed on record
before this court, no case of no case of interim stay of the impugn order dated 17/4/2026 is made out. However, we'll say, however, any further coercive action initiated against the petitioner pursuant to the impugn order dated 17/4/2026 shall be subject to the outcome of this writ.
Or without the leave of the court, my lord.
Subject to the outcome.
Subject to that.
Subject to the outcome. Okay. Okay, then since their appearance, no formal notice, the formal notice stands waived. However, the petitioner shall furnish requisite extra copy to the respondents during the course of the days or within a week from today.
Within a week.
Okay. List is matter after.
My lord, can it be in the first week of June, my lord? And my lord, your lordship has declined to grant me an interim. My lord, I would pray for an early disposal.
Okay.
Let them produce the record, my lord, and the affidavit, my lord.
Okay, then you'll file affidavit.
Yes, yes, lordship.
You are for director.
I'm for the director.
Okay. Then especially for the director, learned counsel in the middle, after notice, the learned counsel appearing on behalf of Mr. J. Gini, learned counsel appearing on behalf of respondent number 5, shall
Produce the record.
produce the record.
Original records.
Original records of the proceedings.
I'll be filing affidavit, lordship.
And with all the original records also. my lord, that is that would be important, my lord.
I'll be appearing for 4 and 5.
No. You are 4 and 5. Records would be with the director or with the nearest?
With the director.
Some records will be with the director.
Okay.
Some records will be with.
I would rather say all records with the director.
Have been impleaded in a personal capacity.
Yes, my lord. I'm alleging, my lord.
Then in that case, the nearest would be able to produce the record, not the director. Director also will represent the nearest, I think, in a personal capacity also. And the nearest means it's the director only who would be producing the record. Then in that case, the nearest respondent number 1 is.
Anyways, my lord.
Okay.
Whoever has the custody, my lord.
My lord, lordship may direct nearest to produce the record so that there is no confusion.
Yes,
correct.
The respondent number 1 and 2 shall produce records of the proceedings.
My lord, the records of this impugn order, my lord, because that would reflect whether any notice or complaint has been served upon me.
Relevant record on the next date.
My lord.
Okay.
Meantime, my lord, we'll also file it.
Oh, all will file affidavit. Okay.
Lordship is fixing any date, my lord?
Can it be
Second
2nd of June, my lord? If
Second
not,
of?
2nd of June.
2nd of June.
But fourth, if I learn has no difficulty, fourth, can it be made 4th?
No problem, no problem.
Let
Fourth.
it be 4th,
Just a minute. 4th is
Thursday.
No. We'll fix on either Monday, Wednesday, or Friday.
Can it be 3rd then? 3rd is Wednesday.
3rd. Okay. 3rd.
All right, man. Let it be 3rd.
Okay.
Obliged.